not yet, no.
The court ready though? Yeah. Yeah. Are they ready to come in? Yeah. Not yet. No. Silence, court rise.
Yes. Well, yes, I was going to make some very brief points about the judge's approach to the agreement and to look at, again, very briefly the agreement.
Mr. Westgate, I think it's probably because I'm furthest away from you, but I was having a little difficulty in hearing at times.
I will speak up and try and be more distinct. Yes, so first of all, the judge's approach was, we suggest, an entirely orthodox one, and not one about which the appellant can or really does make any criticism. He started with the express language of the agreement, entirely appropriately, and then went on to consider what assistance could be gathered. He considered but with the other material that was available to him, and he expressly considered the competing considerations before reaching a final conclusion. All of that is an entirely orthodox application of the iterative approach, and no criticism can be made of it. And it does what the appellant's submissions don't do, which is to recognise the importance of the language of the provision to be construed, and the language that the parties chose. Cases Arnold and Britain particularly. And he then went on to give a clear and we submit correct analysis of the words of the agreement, paragraphs 61 to 79 of his judgment. I'm not going to take you to those, but we do emphasise the point that the judge made, that the principal subject matter of the obligation in the agreement, Kingston to pay for the charges.
Is what?
It is for Kingston to pay for the charges. It's the point he makes in paragraph 61. And that it was then led him to the conclusion that the agreement clearly states an agreement by Kingston to pay Thames Water for services provided to Kingston. That was his ultimate conclusion, and so understood. That agreement fell within the statutory scheme, as he explained in paragraph 64. And he also, in the course of doing that, expressly directed himself about the two clauses that appeared to be out of line with that. That's paragraph 63. And expressly went on to consider the agency and on behalf of constructions contended for. In relation to both of those, we suggest he was plainly right. There was no support on the wording of the agreement for this being an agency agreement. In particular, there's nothing and this is paragraph 69 of the judgment, there was nothing to authorise or require Kingston to collect charges. There was no hint of any control being exercised by Thames over Kingston. On the contrary, Kingston was entitled to collect or not collect any charges for itself, for its own benefit, and it had no duty to account for them to Thames in any way. And those points we make in our skeleton at paragraph 29. And on the face of it, Kingston had complete freedom as to whether or not to make any charge to tenants. Much of that carries...
In theory, leaving aside entirely other considerations which would obviously arise, it could, for example, have decided to pay these charges out of other income.
Yes, well, one can be, if in some way it came into funds for some other reason,
It sold a hot
or a benefactor, a benefactor with a close interest in the water industry, had made some funds available. Yes, they wouldn't have had to recover anything from the tenants.
What would have happened if Kingston had decided it was going to charge its tenants an all-inclusive rent and itself undertake to the tenant to pay any water charges? Would that have been lawful?
Well, in terms of this agreement, it would have...
Oh yes, but I mean just in terms of Kingston's responsibility as a housing authority. Can it simply say, well, you tenant are going to pay an all-inclusive rent, it includes water, it includes services, it includes everything?
There's no reason why they can't do that. The question is what impact the water resale order, because the resale order doesn't render any agreement unlawful. It simply defines consequences about how much you can charge. In that kind of case, it may be that one would have to interpret the water resale order as requiring some kind of apportionment, so that you'd arrive at the amount that truly represented that because what represented the water and sewerage element.
Yeah.
So for much of the reasons that dispose of the agency argument in relation to the wording of the agreement, also apply to the on behalf of language. But again, as the judge pointed out in paragraph 78, whatever meaning on behalf of has, it has to be the collection and recovery which is on behalf of the undertaker, and not the agreement. And so it might well be that the agreement itself is a benefit to Thames Water, because they don't have to deal with the charges anymore and they can hand it all over to Kingston. But that doesn't make it on their behalf. Certainly not if one's reading on behalf of as meaning for the benefit of, because that has to arrive from the collection and recovery. At the point of collection and recovery, there's no link between Kingston and the undertaker. So before coming on to the criticisms of the judge's approach, can I ask you to turn to the agreement? There are just a couple of points I wanted to pick up on that. It's tab A in the core bundle, page 153 to 154. And the first point is to address the charges and the voids allowance of 3 months. The first point in relation to the charges is that the agreement isn't to pay the charges as such, or isn't to pay rather the tariff, the charges scheme tariffs as such. Those are a starting point for the calculation of the charges that have to be paid. And I make that point to demonstrate that what is being agreed to be paid here isn't the charges scheme tariff that would be applicable to the tenant. It's a net amount. And it goes further than that, because as my Lord Justice Lewison pointed out, at 3.1, the effect of the voids allowance and the definition of it applying to properties unoccupied for a period of less than 3 months, is that Kingston ends up paying which isn't chargeable under the charges scheme at all, because unoccupied properties aren't charged. And that too breaks the link between the charges scheme and the way in which the charges are calculated under this agreement. And that has an implication for the on behalf of way of putting things, because paragraph 20 requires that the agreement is for the collection and recovery on behalf of the undertaker of the charges fixed under Part 5. And Part 5 brings in the charges scheme. But if the method of calculation is departing from the charges scheme, then whatever else may be said, these aren't charges scheme charges. And so the only way in which they can arrive is as being payable under Part 5 is through this agreement. But what the appellant's argument has to be is that this was an agreement that was at all times for collection by Kingston of charges that were owed by the tenants. And not only is there no hint at all of that in the agreement, just as there is no hint of any of the language tracking paragraph 20 of collection and recovery. But it's clear that the only obligation to pay lies on Kingston. Indeed, it can't track, or it doesn't track, exactly the liabilities that would be imposed on tenants. And in addition to that point, if one looks at the payment terms, again, that emphasises the provision of service to the customer, because it's the customer, i.e. Kingston, who receives the invoice from the provider. The only other point I make on the agreement is in relation to commission. There was a discussion about that. Paragraph 3.1 identifies the commission. Paragraph 3.2 identifies the commission, says the percentage amount. But that's the only role that the commission has. It's simply a label or description of the 9.3%. It doesn't link in any other way to any of the other operative parts of the agreement. Contrast, we say, the term customer, and while we accept that that can also be said simply to be a label, it appears in parts of the agreement that have an operative effect on the principal subject matter of the agreement. So in the recital, we've got customer paying for the services, we've got the same point in 2.1. And so whereas commission simply appears as no more than a label, the reference to customer is woven into the fabric of the contract in a way that the isolated references to commission aren't. The only other point we make in relation to that is that commission is perhaps qualified by paragraph 2.2, where it's described as an allowance or reduction, which isn't redolent of something being provided in consideration for a service. If I can now come on to the grounds and the criticisms made of the judge, I can take grounds 1 and 2 together, because in substance they come to 4 propositions. Firstly, that the judge wrongly put the history to one side for no good reason. Secondly, that if he'd had proper regard to it, he would have recognised the commission was in consideration for collection services. And thirdly, he would have read the 4.6 referring to the VAT attributable to the collection part of that commission. And fourthly, he would therefore have recognised that the collection service offered by Kingston was a relationship with agency and or on behalf of Thames Water. And so both of those ways of putting the case, the agency or on behalf of, really depend on the same fact. So I'm not going to distinguish between them for the purpose of this part of the argument. But the difficulty that each of them has to overcome is the absence of any reference to a collection service or obligation or agency or anything indicating it on the face of the 2003 agreement other than the references to commission and VAT. The appellant's arguments, we say, have to fail here, whether they're directed to agency or on behalf of. Firstly, because the judge's reasons for not deriving assistance from the prior agreements was sound. Secondly, the argument fails on the facts, because on the facts found by the judge, it's not the case that there was, prior to 2003, a collection service in return for the commission. Put another way, the court couldn't be satisfied that if the same issue had arisen prior to 2003, then the agreements wouldn't have been held to be resale agreements anyway, within the Water Resale Order. And thirdly, in any event, and whatever the history, it doesn't help here because the gulf between the words used and what AU wants to make them mean is simply too great. So if I can deal first of all with the judge's approach to the prior agreements. He set out his reasoning here at paragraphs 85 to 6 of the judgment. And that's, well, in fact, one should start really from 84, where he refers to the passage from HIH from Lord Justice Riggs. He then explained that the 2003 agreement expressly superseded the earlier agreements, plainly wasn't identical to them, and as explained by Lord Justice Riggs, where the terms of the contracts differ prima facie from the second contract involved a deliberate decision to depart from the wording of the earlier agreements, whatever precisely they were. So they're unlikely to be of any assistance. And then he also noted that the statutory framework was the same. It wasn't the same. And so in the result, he didn't derive any assistance from them. Now, if I can deal with the first of those points, the reasoning based on HIH and Hill, can I ask you to turn to that case, not for the passage that's in the judgment, but for the preceding passage. It's tab 16. And this was a case where an insurance slip policy was succeeded by a fuller policy. In the end, or in the event, the issue didn't arise as to how far the slip policy could be used to supplement the policy, because it was found that the policy bore the meaning contended for on its own. But
the discussion in HIH is about looking at a prior contract between the parties.
yes,
We haven't been shown any authority which allows one to look at a prior contract between different parties.
I'm not aware of one.
Because the contract on which Mr. Bowes wishes to rely is not a contract between TWU and Kingston. It's principally a contract between Thames Water Authority and Kingston.
That's right. I think the effect of Mr. Bowes' argument is that the terms of that agreement were adopted by Thames Water Utilities, TWU. And I'll have a little bit to say about that in due course. But certainly, if it, in the absence of that kind of nexus, it's hard to see how a contract between other parties can be material, because unless there's some indication that it intended it to have a similar effect to that of a contract between themselves. Just as Lord Justice Riggs says, it may be impossible. It may be that one can't draw an absolute rule about that, because if the indications are that a new contract is intended to mirror that contract, then that may be of some assistance in some way. But it certainly doesn't follow that a contract between parties A and B will assist construing a contract between A and C. The before I get to the passage in paragraph 81 and 82, can I ask you to look at paragraph 73, where there's a citation from Ewell and Bland Welsh. And if I can ask you to pick it up at paragraph, at letter F, beginning Mr. Sumption. And this is where the point's being dealt with as an aspect of the parole evidence rule. But the point he makes here is valid, we say, in this context. Where it says, where the slip provides a formal wording to be agreed, then that the parties agree the final wording, which will spell out their rights and obligations. The differences between the wording of the slip and the formal contract, which is embodied in the policy, give rise to the possibility. The natural meaning of the slip differs from that policy. The natural assumption is it should be embodied in the policy to be designed to better reflect the agreement between the parties. And that, even on the way that the appellant puts their case, it encapsulates something of the position said to be the case here. Because what they say is, well, we had this rather informal arrangement, and we decided to put it all down in writing. And it must, the obvious inference must be that what you intend the thing to bind you to be the written agreement, and not what had gone before. But if I can then ask you to turn on.
Well, I do regard this as really quite a tenuous ground for, as it were, sustaining the judge's judgment. I mean, this is a reference to an insurance industry practice of the slip in the policy. You've got to be very careful about saying, well, obviously he intended it to mean all cases where there's an agreement followed by a more detailed agreement.
I'm not suggesting that he was laying down a principle of that kind. My point is, in a sense, a more general one, which is an example, which is that if you've got something informal and you then replace it with something formal, and then the parties, and the language that Mr. Bowes uses in his skeleton argument is that the parties were reducing their agreement to writing, is the way he puts it. But if that's what you're then trying to do, then the place to look for what you meant is the writing.
I'm not sure you need to refer to this passage for that proposition.
But no, perhaps not. But the point, the passage that I do want to take you to is paragraph 81. Where Lord Justice Riggs, saying that there's nothing that binds the court to find that where a prior contract been followed by a further contract, there's a rule of law that makes it inadmissible. He then goes on to say, and it's the last sentence of that, last two sentences of that paragraph, where it's common ground that one contract's been intended to supersede the earlier contract, it must follow that the parties' contract must be found exclusively in the later contract. Thus, the earlier contract cannot be used to add to or modify the later contract. And then he then goes on to say, well, how does it follow the earlier contract? Can't even be looked at for the purpose of construing the later contract. And that's the passage that we have in the judgment. So what he clearly draws is the line between permissible recourse to prior contracts, which is permissible in principle but usually idle in practice, to construe, and the impermissible line, which is you simply can't use the previous contracts to add to or modify. And we would add to that, or to imply terms into the new contract.
Well, the essence of it seems to be that you should take a cautious and sceptical approach to finding any assistance in the earlier contract. That, he says, is the sound principle.
Yes. And the explanation for that is that if there's no difference, you don't need it, and if there is a difference, there's intended to be a change.
Well, in this case, there was an express provision for super...
No, exactly, clause 9.1.
Yes, 9.1.
And so this is clearly one of those cases where the parties intended their agreement to be governed by the 2003 agreement, not by something else.
Yep.
And one can't say that simply because some terms are the same, even important terms, that some different principle applies, and one then has to strive to construe the new contract as not affecting any change from the old. But that, in effect, is what the appellants ask you to do. Their core terms analysis seeks to say that because picking out some terms that they identify as core are shared between these contracts, there must have been an intention of continuity. And that observation simply doesn't carry them that far. Quite apart from the fact that the selection of core terms is one which is difficult to discern a reason behind, because what Mr. Bose doesn't include in his core terms is what the judge identified as the principal subject matter of the agreement, that is the payment by Kingston for the services, and nor does he identify what is emerged as really the key foundation for his case, which is the obligation on the part of Kingston to collect charges, which he says must have existed prior to 2003. And that, surprisingly, isn't one of his core terms. And even on its own terms, the appellant's argument ends up proving too much, because if the 2003 agreement simply repeats in substance the old agreement, then it could just as easily be said that in fact the early agreements were resale arrangements, as it can be said that the 2003 agreement has to be twisted and construed in such a way as to be an agency or on behalf of. So the...
Well, is that quite right? I mean, in the 70s, which I think is when Mr. Bose says this agreement was made, was there such a thing?
No, there wasn't.
As a resale order?
It only came
so
into force.
It wouldn't have been of the slightest concern to either party whether this was or wasn't a resale.
Well, no, indeed. And it's... well, we can't speculate about what happened then, but certainly at that stage there may have been little reason to think in great detail about what the shape of the agreement was.
Yeah, so the point you're making is that it might have been considered to be a resale
Had the
order been enforced, but in the 70s that was an irrelevant question.
No, it wasn't. It would have been a relevant question between 2001 and 2003. Yeah. But the point is that you can't say that the argument runs only in one direction, and that if there's intended to be continuity, then it must follow that you have to read the 2003 agreement as being something else.
Yeah.
Why not read the previous agreements as being the same as the 2003 agreement? So as an exercise, we suggest it's simply the wrong way to approach this, and one simply cannot derive from the fact that there are some core terms, even if you can identify those core terms, that creates an intentional presumption of continuity that then drives your construction of the 2003 agreement. The judge's second reason for not finding the previous material useful was the statutory framework being different. And complaints made about that, but the judge was well aware of the statutory scheme. The fact is the powers had changed, and this may feed into the point that my Lord Justice Lewison makes, that you can't assume when the statutory scheme has changed, the basis for charging has changed, the parties have changed, that in 2003 the parties to that contract were expecting or were intending to create something that achieved continuity with an arrangement that's said to go back to 1977, 1978. But in any case, it's perhaps hard to see what the reference to the statutory scheme adds here, because it's difficult to identify how it has a bearing on interpreting the meaning of the words. And Mr. Bose doesn't, in fairness to him, really identify one. His argument turns on commission and VAT. What he's not able to do is say that, well, if you look at the statutory background, that means that one must have construed the contract in a particular way. That the furthest he gets is to say, well, when you look at the statutory background, the authority had the power to enter into these agreements on behalf of the undertaker, and therefore they must have been intending to do the same thing here. But that's vulnerable to the point that the judge made in paragraph 81, which is that, well, if that's what you're doing, then it's astonishing that one doesn't have any reference to that provision in the contract, or indeed any language tracking that provision. So there's no reference to collection or tenant's liability or anything like that. No reference.
Can you remind me, was there any reference to VAT in the earlier arrangement?
There doesn't appear to have been any, and it's certainly not one that Mr. Bose identifies as one of the core. He identifies as a core term, but
yeah,
but he says it's new in the 2003 agreement.
Certainly, there's nothing about VAT in the judge's summary at paragraph 55.
Would you bear with me? And Mr. Bose may be able to correct me on this, but we haven't seen any, I don't think there was any evidence of any charge to VAT being accounted for prior to the 2003 agreement. I think that retrospectively it did after the 2003 agreement for previous years, but I don't think there's anything after the 2003 agreement. Mr. Bose will know better than me. But certainly as far as the contractual terms are concerned, the VAT appears for the first time in the 2003 agreement, and as it appears in some of the other agreements that seem to have followed the same model, two of which you have in So that's the judge's approach to the agreement. We say can't be faulted. Secondly, my second point is about the factual basis for the prior contracts having any impact at all. The judge's summary of the arrangements is at paragraph 55, and the appellant doesn't appeal on those, and doesn't, certainly in their written submissions, criticise them expressly. But what they have today said that, or attempted to go beyond that, and attempted to go further than that. And in response, I think, to a question from Lord Justice Arnold, they said that one of the criticisms of the judge was that there was that the judge ought to have worked out what the terms were, and that's what.
Well, I thought what he was saying was the finding by the judge that the arrangement was described in the letter of 1977 as being an agency arrangement was not good enough. The judge should have gone on and found what the actual arrangement was.
Yes, but that's what he did. If one goes to paragraph 49 of his judgment, it's. Sorry, I've got the wrong reference. Yes, it's paragraph 43. He, having set out the respective arguments, he said, before dealing with those submissions, the last sentence, I need to make my findings as to what the previous arrangements have been. And he then proceeds to deal carefully what the agreements were, and then at 50, it's around 55, sets out his 6 bullet points.
Yeah, and he is careful throughout that to say that these are arrangements, and he expressly finds that there was no formal agreement which recorded these arrangements.
Yes.
So, in effect, therefore, there was no contract. I mean, depending, of course, what you mean by a contract, I appreciate, but certainly there was nothing that you could equate with a written contract.
It's certain, yes, he doesn't find a contract as such, and he also doesn't find, there's perhaps maybe another way of putting the same point, he doesn't find any authority or obligation to collect on the part of TWU as consideration for any commission offered by TWU. He says the sum which was called commission was to compensate Kingston, but that is apt to describe the factors taken into account in calculating it, and doesn't imply or say that there's any authority or obligation.
So here you're relying on what the judge hasn't found.
Well, we're relying on what he expressed, what he found as being a careful enumeration of what you could get from the background, and it's the question whether or not there was an obligation, what the nature of the agreement was, and whether there was an agency was at the heart of the argument for the judge, and it's significant that he didn't find that there was an obligation to recover. And it's critical to the appellant's case that the prior arrangements, whatever they were, did contain such a obligation. And they can't extract it from the judge's findings. And what they seek to do is to invite you to go beyond the judge's findings without having included this as a part of their grounds of appeal. And to seek to find that in what they say is the terms of the 1977 letter, which they say were then accepted and formed a contract. And if I can deal with that very briefly, the first point is that it's not at all clear that there were terms of the 1977 letter. It proposed a particular commission, and it proposed a 0.25% increase in relation to the voids amount. But the overall tenor of it is that it seems to be a matter for discussion with the authorities. It's much more an invitation to the authorities to treat. But also that much of the letter is commentary. And if the appellant's going to say, well, the terms of the 1977 letter, what bits of the letter do they say are the contract and what bits do they say aren't? And that's important when one comes to say, well, what was the obligation?
So just putting that in my own words, so I can check I've understood that submission correctly. Do I understand you to be saying that if you hypothesise that the 27th of October 1977 letter is an offer, and there's then a response to it simply saying, we accept, or you then try and figure out what the terms that have been accepted are, you're in a state of considerable uncertainty.
Well, you are, and then the uncertainty is compounded when one reflects that one doesn't have a letter that says we accept. Yeah. What you've got, if we go to the supplemental bundle at page 38, is a minute of a resolution that doesn't refer to the 1977 letter. It says, resolved that the following arrangement with Thames Water Authority in respect of housing revenue account properties with effect from 1st April 1978 be accepted. And then it's got 2% commission for collection of water rate and sewerage, and a void allowance of 1.75% in respect of water rates. Now, the 2%, it's fair to say, is the figure that was put in the 1977 letter. We don't know whether the 1.75% was, because what was being suggested was a 0.25% increase, and we don't know what the original amount was in respect of.
Well, the letter was proposing two different methods of calculation.
It was proposing two different methods of calculation. It was also proposing it in relation to the combined charge, and this appears only to be in respect of the water charge. So what you've got is this document, which is some 4 months plus past the 1977 letter, and we know nothing about what led up to it. What it seems to suggest is there's been something's passed between Kingston and Thames, between the 1977 letter and this. We've got no idea what that is. It doesn't refer to the 1977 letter. For all we know, the tenor of those discussions were, well, we're happy with this amount, but we don't want to undertake any obligations to you. All this does is say that there is a figure called commission and there is a void allowance. And one simply can't say that that is a foundation for accepting an agency or a collection service or a collection obligation taken from the 1977 letter, and nor did the judge find. And the second point is that even if the judge would have been required to hold that the 1978 agreement was on the terms of the 1977 letter, it can't follow that that's carried through to Thames Water Utilities after privatisation. And again, the judge made no such finding. Because what we see when we look at the dispute that arose between the parties, shown at page 44 of the supplement document, 45 of the supplement, sorry, 48 of the supplemental bundle, it is an exchange between Kingston and Thames Water about the way in which you should calculate the voids and the commission. Should you take the voids off first, so that the commission's on the lower amount as Thames are contending, or should it be a composite reduction? And Thames there said, page 49, we've no record of suggested agreement, which took effect from 1st of April. And then there's a further letter referring to a 1977 agreement. And then at page 52, we've got Thames saying, I'm afraid we've no record of any agreement in 1977. We've not received a copy of it following our request. And then Kingston send a copy of the letter, page 54, saying it's the second time they've sent it. And then we don't have any further correspondence on that. But what does appear then to have happened is that
They also seem to disagree what the agreement was.
exactly, what then happens, or appears to happen, is that the voids are indeed taken off first. So the Thames approach is taken, and that's not what Kingston thought the 77 letter was saying. So how can one say that the 77 letter carried through to the Thames Water arrangements when they can't agree what it means, and Thames don't even think they've got the letter? So it's the foundation that the factual foundation the appellant seeks to lay for its analysis that there was a finding of an agency arrangement or a finding of an obligation to collect prior to 2003 simply isn't made out on the facts found by the judge, simply isn't a finding that the judge would be compelled to find on the facts before him. And as a result, the appellants overstate what can be gathered from the earlier agreements. And they simply are not in a position to assert, as they do at paragraph 53 of the skeleton Mr. Bowes did today, that the commission was a sum paid in consideration for the collection, which necessarily implies an obligation to collect. So finally...
what was it paid for?
Well, it was just a
paid for
way of
something.
accounting. It reflected the fact that Kingston took on the burden of, as a matter of fact, of collecting the money or recouping the money that they'd paid from their tenants.
Discount for
Plus the
payment
risk
is
of non-payment.
Exactly.
It's got the risk of voids, that's catered for, and it's got the risk of non-payment.
Yes. And which is exactly the kind of thing one would expect in a...
Then if you've got lots of tenants on benefits of one kind or another, there may be serious gaps in payment.
Well, yes, well, yes. What it doesn't cover is delay in payment as well, which of course the other matter.
Will Kingston have the risk of that? They've got to pay interest on
Yes.
late payments.
Well, I know all that. I'm not sure that's really answering my question, because we're trying to find out what the basis for that is. I mean, is that a voluntary offer by Kingston, or is it something else? I mean, it seems, I I don't know. But I mean, just to say that what the commission is for doesn't tell you really anything about the reason why the service was assumed.
Well,
I mean, the simple answer that's given by Mr. Bose is it's either agency or on behalf of. But I'm not quite sure what you're saying it is.
Well, what we're saying is that all we know is that there was a reduced payment from Kingston to Thames. That reduced payment was called commission and avoids allowance, but it could either be a discount for bulk payment, or it could be a non-contractual agreement, or it could be in consideration for some services. But the fact is that the judge didn't find that consideration for services was made out on the facts, and that's the reason I'm making this point is it's an essential building block of the appellant's case that there was an agreement for the commission to be paid in consideration of a collection service. And the fact is that simply doesn't appear on the documents, because it's as equally explicable as a discount, which is the way it appears in the 2003 agreement. And then it's for the appellants to demonstrate that this chain in their reasoning can be established on the judge's reasoning, and it can't be.
Well, I think where it lies at the moment for what it's worth is you say there's nothing in the acceptance, whatever the proposals are, from the 1977 letter that refers to the assumption of an obligation. That doesn't appear there. You say there was no finding by the judge that there was an assumption of an obligation, whether it's an agency or on behalf of something else. And you say, then I think you simply say, well, that's where matters stand, and the explanation for why they were getting the commission is for the reasons that are mentioned.
Well,
I'm not sure how far this takes us. I mean, we're kind of descending to the most minute detail. I mean, at the end of the day, your case, the gravamen of your case is, apart from the fact that the judge didn't make this finding, which I think is an important point, and there's no challenge to the findings, or no appeal on the grounds that they were inadequate. But leaving that aside, the basic gravamen of your point is that there's, first of all, there's nothing explicit about any such obligation. There's nothing explicitly in any of the documentation for 2003 that refers to an obligation. And in any event, we've got all the points you made previously about a new agreement, which expressly supersedes previous agreements between different parties in a different statutory regime. I mean, that seems to me to be kind of the substance of it.
Well, it is, but the reason I dealt with the 77 letter and the correspondence is Mr. Bose took you to it this morning and sought to make something of it. But certainly we rest on the judge's findings.
Yeah.
My third point on this, which I think you have already, which is the interpretation point, which is that even if the earlier agreements said what had the content that Mr. Bose says they had, then it doesn't assist in the construction of the 2003 agreement, because it is simply going beyond interpretation and crossing the impermissible boundary into modification. The appellant only points to two terms of contestable meaning, the commission and the VAT point, but those both fall because in the 2003 agreement one simply cannot find the service to which they relate. And that, in substance, is the judge's reasoning at paragraph 69 when he was dealing with the agency argument, when he was going through the express wording of the 2003 agreement.
Right.
And we come to this part of the argument at this stage on the basis that this is a complaint of the judge's approach to the history. But really, the history, if one takes it into account, can't add to the substance of the exercise that the judge conducted in paragraph 69. The purpose of relying on history would be to say, well, commission must mean, well, commission ought to be read as having a point of reference in a service being provided. But that was the point the judge took anyway, and it's not made any stronger by the appeal to history. So the only two further points I need to deal with are the relevance of the Water Resale Order and the relevance of lost rights,
Yes.
which Mr. Bose dealt with this morning. The complaint is that the order made the agreement uncommercial. The fact is, it may have done from the appellant's point of view, but ultimately it gets them nowhere, or only gets them so far, because they can't suggest how that would lead to the terms of the contract being construed differently to the way they were. And that really makes it somewhat academic to get into the argument about whether or not this is something that's reasonably available to both parties. But we do note there that this is a somewhat odd use of that maxim, where the thrust of the argument isn't to say, well, the agreement should be construed against the background of legal knowledge that we should all have had. The argument is, well, against that background, we would never have entered this agreement, or certainly never have entered it in this form, and therefore it needs to be read in some different way. And the difficulty with that is that, of course, they did enter the agreement, and the only available indications one gets from the corners of the agreement must be that they didn't have the provision in mind, and therefore it's difficult to say that it can be used as an aid to construction. Indeed, the appeal that is being made by the appellants to use the order elides too far into really being the same as the impermissible type of argument that one can use that one cannot use the legal consequences of an agreement to change the effect of that agreement or its classification, as Shell makes point. So the WRO doesn't help in that for that reason. But in any event, although it may have been uncommercial from the appellant's point of view, it wasn't uncommercial from Thames Water's point of view. Because as far as they were concerned, it may be even more beneficial to have a resale, because they then play no part in the arrangements, other than the express obligations they've got in the But ultimately, the point is that the argument can only get them so far, because it can't change the language of the agreement, and they haven't suggested how it can change the language of the agreement. The same really applies to the lost rights point. And again, one can make detailed points that those don't really create a significant problem. For example, if the water supply will continue under Section 52, it perhaps isn't the most significant concern about not being able to request disconnection, and it probably is the case that the occupiers can elect a meter anyway. But leaving all of that aside, there's nothing to suggest that either party would have sought to avoid those consequences. And in reality, they're really complaints about the existence of resale.
It would seem counterintuitive to suppose that Kingston would let a property without a water supply connected.
Yes, and equally that they would they wouldn't take any action if the water supply was cut off. If
there are restrictions, aren't there, on cutting off water?
You can't cut off the debt, but the Section 52 duty is one that would cover interruptions for other reasons, and and then of course in section 60 there's the power to disconnect certain works. But it's unrealistic to think that Kingston would just let that happen and not take appropriate measures to notify the tenant at least. But let's say that the real complaint about these is that it's a complaint about the existence of section 150 in the first place, or the existence of these kind of arrangements, because that is simply a consequence of having those arrangements and interposing somebody. But Parliament's authorised it. And if Parliament's authorised it for private parties, then it has the same effect with a responsible public landlord. So it simply can't.
So the same would presumably be true of the owner of a mobile home park.
Well, exactly. And there, one might say that the
occupiers of the mobile homes wouldn't have any right to complain if the water got cut off, or wouldn't have the right to demand a supply for their own mobile home and so on.
Yes. So they aren't factors that one can assume the parties would have had in the back of their mind when drafting or intending this agreement and interpreting it. But even if they were, again, the same point applies, that they don't actually help tell you what the words of the contract mean. Would you bear with me? I think that's... Lords, unless there's anything else.
Thank you very much. Yes, Mr. Burns.
Well, the measure would reply on 3 points, very briefly, please. First, in relation to the acting on behalf of, no friend submitted said it is unclear what we said, why we would need to rely upon that if we got home on agency. Our position would be that if the court is unable to interpret this agreement as a contract of agency, for example, because of the absence of any express obligation to collect or any other provision that one might expect in a contract of agency, and one can't imply terms either, then one could still, in those circumstances, conclude it was nonetheless an agreement under which costs to be collected on behalf of the water undertaker, because that doesn't require the same elements of agency. That's the point. So if we're right, and that all it really requires for an agreement by the authority to collect charges which the undertaker would itself have collected, and if that suffices, then the fact there are no other obligations doesn't matter. But I agree that that may not matter very much in this case. The second point is, my Lord Justice Lewison is quite correct that the agreement was made on the 1st of April 1978 with the Thames Water Authority. I accept that entirely. Our point is that the contract on the same terms was adopted and continued by Thames Water Utilities on the 1st of April 1990. And I already took my Lords to the letter of the 14th of June 1990, page 39, the supplemental bundle, written 2 months after Thames Water came on the picture, talking about reminder and the like, entirely consistent with the pre-existing relationship. And the third point is a point raised by Lord Justice Arnold, who noted that we haven't appealed against the judge's findings of fact in paragraph 55. Well, that's absolutely right. And it is an error in our drafting, in that it's clear from our ground one that what we're criticising the judge for is not having found that under the prior agreement there was a payment of commission in consideration for collection services. That's how we put it. But I accept that in order to make that point, we need to make an anterior point under ground one, that the judge erred in not having concluded that that previous contract was one under which, in consideration for the collection services, commission would be paid. My Lord, I accept the fault is mine, but I hate the court not to determine all the issues in the case because of that, in the sense that all the arguments have been put to the court. I certainly wouldn't wish to say anything further, but that is what we do say the judge did err. I think I do need to say that, and I do apologise that ground one wasn't as well framed as it might have been.
Of course. Thank you. Well, we will rise to consider where we go from here.
how does one interpret the very terms?
Yeah.
And what are the principles? We certainly don't want to have it in this case.
No.
I'm sure my clients are very happy. Well, local authorities generally won't be happy by that. Oh, what if it doesn't bite?
We're very grateful to both council for their submissions, which have been very clear and very full. We are clear in our own mind. We do not need to hear any argument on Appeal Ground 5. The matter is an important one. It doesn't just affect this particular local authority, but it may be others and other water authorities. We will consider our judgment. Be handed down in due course. When you receive it, please give a form of order. Any further submissions to be invited. Thank you both very much.